When the False Claims Act was originally enacted in 1863, it was done with the intention of ending the rampant defense contractor fraud which plagued the Union Army during the Civil War. The Northern troops were being overcharged for supplies, some of which were faulty and unusable. In response, at the request of President Lincoln, Congress passed the False Claims Act, which issued a severe penalty to those who sought to defraud the government and a reward to those who prosecuted the fraudulent parties. Today, defense contractor fraud or military contractor fraud remains one of the most common areas for false claims litigation. Defense contractor fraud typically involves misleading the government about the cost and quality of the products being supplied. For example, companies might tell the government that the vehicles they're purchasing are bulletproof and worth $200 each, when actually the vehicles are worth $50 each and don't offer any protection. While there are countless ways a defense contractor might seek to procure illegitimate government funds, the three most common defense contractor fraud schemes include 1. Cross-charging. Cross-charging occurs when a defense contractor enters into simultaneous contracts with two different payment stipulations, fixed price and cost plus. In a fixed price contract, the company receives a fixed price for goods and services no matter the cost of production. In a cost plus contract, the government pays the company for the cost of the goods plus a percentage of its costs as profit. If the company charges for the time it spends working on the fixed price contract to the cost plus contract, it's essentially charging multiple times for the same service. This type of fraud is known as cross-charging. Second, improper cost allocation. This occurs when a company has entered into a government contract and a commercial contract at the same time. If the company charges the government for time spent working on the commercial contract, it might be guilty of improper cost allocation and in violation of the False Claims Act. Third, product substitution. In these cases, a company provides a substitute and typically inferior goods rather than the ones contractually agreed upon. If a company substitutes goods without the permission of the government contracting officer, it may be guilty of product substitution and in violation of the False Claims Act. In addition to costing the country billions of dollars every year, defense contractor fraud also weakens our national security and unnecessarily endangers our servicemen and women abroad. For those reasons, it's especially important for persons with knowledge of defense contractor fraud to blow the whistle. The Law Center is networked with whistleblower attorneys who have the knowledge and experience to help you prosecute a fraudulent party in any industry. We can also ensure that you file your reports safely and confidentially, and that as a whistleblower, you're protected from retaliation by the defendant. We can also help ensure that you're properly compensated for coming forward and helping to recover lost government funds. If you have knowledge of government fraud, contact the Law Center to be connected to a partner law firm in our network near you for a free, no obligation case review today.